marketing. Okay. So I think Shizada mentioned quite a few things that relates to finances of a law firm, and the most important thing that any entity needs to remember. Now here it doesn't matter whether you're a law firm, even if you're an accounting firm, but cash is king, and that is where our focus has to start from. So I think the most important thing that any aspiring law firm needs to keep in mind is, because in the way that law firms are structured, most of the time they're set up as either sole proprietorships or partnerships. And there is a tendency sometimes to think that, well, because it's mine, whatever money comes in, I can just take it out. And that is where the problems start. So the first thing that any entity really should be doing is to set up your bank accounts that are purely for business purposes. And in that way, you are at least able to manage your cash flows. When you need your money, you're going to be taking that out in a formal manner, rather than just, well, today I need this, today I need that, and you just take it out of the company. So that is the first most important thing that I would suggest in terms of managing your finances to keep in mind. It's very easy sometimes when you look at your books of accounts and you will see you have a profit, but when you look at your cash book, you don't have any money in there. So what happened to it? And sometimes you will be having a lot of money, but then you will not have a profit. So it's very important to have a distinction between whether you're making cash profits or you're making just accounting profits. The issue around trust accounts and client accounts is another very, very important point to raise. As accountants as well, we often deal in situations as well where clients will send us their funds to distribute for payroll purposes, for example. And the first thing we did was set up separate client accounts. To the extent that, best practice would be that for every client that you're going to be managing funds for, you would have a separate account for them. And in that way, even when it comes time, you may have a situation where the client hasn't sent you the money. They're like, oh, but I'm running a little late, can you please pay? You just send them that bank statement and say, buddy, I don't have your money, I'm not going to be financing you. So you lay these ground rules out very early, that what money belongs to the client will be used only for client purposes, and your money will be used for your firm's purposes. We talked a bit about having budgets and plans and cash flows. This is extremely important. Now, when you're doing your budgeting, there are two ways to look at it. One is you do a profit-based budget, in which case you'll be looking at your your profit, less your expenses to get to the profit. But the other way to look at it is actually the other way around. You start out with the profit that you want to have. So if you know what your top line is, you know I need to have a bottom line of a certain percentage. And that way, you know that the limit of your expenses is what is left. So rather than doing revenue minus expenses to get to your profit, you're actually going to do revenue minus profit. What's left is what I can spend for my expenses. So when you're looking to set up and you want to control your expenses, this might actually be a better way to sort of keep track of where you are on your journey towards your growth. Disbursements and reimbursements is such a key point. We'll talk a bit more about costs and how to manage that as well when we look at what are better ways to control the costs. But absolutely, the amount of stationery that you will end up using, printing, and we don't factor that in. You're going to have a printer in the office. You'll have to constantly replace the toners. Who's going to pay for that? Because you will be using very little of that for yourself. The majority of what you're going to be printing is actually for the client. Software here plays a very important role. So for example, in our practice, what we did is we engaged with a third-party supplier. We've got a printer where any document that is printed is actually coded. So if I want to print a document, I need to allocate it to a particular client. At the end of the month, I pull out a report and it tells me, okay, you have printed these many documents against this particular client. That way, I can even prove it to my client that, look, these are the reports we printed, this is the cost, and it allows it makes it a lot easier for you as well to justify the costs that you are incurring. professional indemnity insurance. You know, when you start talking about managing finances, we tend to forget that our industry, and here when I say our, you know, law and our practices of accountants as well, we are very highly regulated. You know, we have standards to meet, and there is all sorts of regulation behind us. Having that professional indemnity insurance will just relieve this load of what if things go wrong. So, although it's not directly linked to managing finances directly, but certainly there's a big impact. Should anything go wrong, at least you're covered to that extent. I want to make one point on specialization. This is an audience of lawyers, and your area of expertise is law. When I was looking at those first few slides that Shazada put up, and we look at the structure of a law firm, and there was that whole area in there about these additional resources that you have to keep at your office. Now, I want to ask you something. Is that really necessary? Is it really necessary for you to have all these additional resources? Would it be easier for you to identify a third-party outsourced consultant to handle some of that for you? It will also make it easier for you from a tax perspective, because when you're hiring someone, you have to handle all your regulatory requirements and your compliance with respect to payroll taxes, etc. If you're outsourcing it, it doesn't become your problem anymore. You will get an invoice at the end of the month for which you will pay, and you move on. Your only impact is there on reporting taxes. So maybe we also need to relook at how to make our offices leaner, focusing on what our core capabilities are, and are we able to deliver on that? But again, a word of warning. The right consultant is also very important. I recall that whenever we put up proposals, the one thing that we have when we have our discussions around fees is the notion that cheap is expensive. So I think this applies to your industry as well. I mean, we talked about clients asking for discounts. At the end of the day, there is a certain quality that you are selling to your client, and in our industry, it's the same thing as well. So if you're not going to pay, I wouldn't say top dollar, but at least if you're not going to pay for what you want, then you will not get. Then you will get what you deserve. One final point I think that I can make on managing your finances is around the billing cycle and the challenges that go around it. Your clients will not pay you on time. Your main outflow is your staff. Your staff need to be paid on a month. I mean, for them, it doesn't matter whether your client is paid or not. So let's re-look at how we're actually doing these billings. Looking at ways of billing, such as having a retainer rather than having a fixed fee, but you set it up. Okay, you might agree your fees, but then you've agreed that, look, I'm going to be billing you this fee within the next 3 months at a particular rate every month. You can look at mobilization fees, for example, where 50% of your fee is paid up front, and your draft report will not be issued unless that 50% is cleared first. Your draft report is followed up with a 30% invoice that goes with the report, right there. And your final report, the signed report, because draft reports should never be signed, and your draft report will be given with that, and the final report is only issued once all the fees have been cleared. So we need to have a little bit more of a little bit of a strictness around that, and maybe have someone in your office whose job it is just to call up your clients and say, by the way, just a kind reminder. You call someone every day at about 9 o'clock every morning to say, my invoice is still pending, my invoice is still pending, and eventually, just to stop that phone call, they will pay you. So that was just a few points from my side around the management of finance.
Yes, I think you make a very bad panelist. You should stick to moderation.
I should, I'm sorry.
I might need some legal help. I think you stole some of the questions I wanted, because I wanted to stay on the money part early on, to just read from what Shazada said, but then I have to take the mic from you and give it to Charles. Charles, as a person who has been in this industry for quite some time, what are the tips to run a successful law firm? And the second part of that question is, bridging up from Shazada's presentation on the structure. I know he mentioned about the sole proprietorship, partnerships, and the company limited by share. Though it is not prohibited doing that, do you think that is a way to go Because our law society are regulating practitioners as opposed to law firms as companies, as opposed to, let's say, engineering, which you license a practitioner or consultant engineer, and there are other companies, which we don't have that in the legal sector. What is your view on this? So the first question is the tips on running a successful law firm, and what is the best structure? From what Shezada said on the sole proprietorship, the partnership, and the company limited by share, limited liability company.
The choice between what kind of law firm you want to work with is the choice is wide. It is as wide as it is varied. What Shezada has projected to us is the most ideal law firm structure. It has a top, it is fully packed. Shezada, if I may use the term, it's a firm, a law firm made in heaven. If you have a law firm like that, you are very good. Unfortunately, in my opinion, and I would say from my experience, you don't have law firms so well set up. And even if it was possible to achieve that idea, the route to that place has got so many hurdles. The most obvious is financial outlay, both at inception and as you go along. To have a law firm of that size needs office space, which definitely is going to be costly in the times we live in. And it actually runs counter to the current trend of having a matchless mortar and the cement offices. Virtual offices are now going to be the trend for law firms. Minimize costs that go with physical office space. So, without taking the sting out of your presentation, I would say, Shezada, that law firm will work, but at least 50% of it should be virtual. To have a librarian today, honestly, a librarian in the form of a human being managing a room with so many books in it, it will look fancy, but it can, what you seek to achieve can be achieved without such without a library with physical features of that nature. I visit the High Court Library here. I rarely find 5 people in it. And the books that you see there, I doubt whether anybody read them. If you open them, pages would be. So we have a good library, very well stocked, very impressive, but honestly, its utility is maybe 10% of what the original conceiver, those who conceived it, intended it to be. So when we are talking of office facilities, let's see what we can do without and yet achieve the same purposes. On a computer, or even on a handset, a young man can do their research and deliver quality opinions without having to go to any book and open it. And I think that's the trend law firms should be. I noticed there is a circular going around which, if it is true, someone is going to be coming from the office of the registrar of the High Court to monitor, to physically monitor chambers. They will see much less of what they expect. We used to undergo that exercise formally before you could be enrolled. The registrar would send an envoy to where you want to practice from. They would count the books you have. They would look at the physical structure of your workplace, and they would get licensed, admitted or not, depending on. So I remember stories of people setting up offices for the sake of being vetted. And as soon as the registrar disappears, the books disappear, they go back to where they are supposed to be.
After the general's chambers, because they are the ones only one.
Precisely, you follow them from. So what am I saying in all these many ways is the ideal law firm that Shehzada has projected to us, and let me say it, I'm not saying you projected a very wrong concept. No, it's a very good concept. My problem is the physicality, if I may say so, of the setup. If you can achieve what you want to achieve virtually, that would be, to me, the most ideal situation. Let me give an example, taking on the need to have specialists. I can liaise with you, Shehzada, on a transaction. For the sake of it, let's take an IPO transaction. We don't need to be together in a room to accomplish a due diligence for the purposes of a transaction. We are working together with Shehzada on another project. I'm working with his firm. And we hardly meet, and the project is going on. We could do so even when we are in the same law firm. We don't need to sit around the table, face masked, and start reading books. You can do that remotely, virtually. And in my opinion, we should be able to achieve what Shehzada wants to achieve in a physical room without having to incur expenses and to use resources on items that we could do away with and yet perform very well as a law firm. That is one, and I think you reacted to it at the right time. The other challenge towards getting to that ideal law firm, I will use the generic term resources. You have human resources, and that is the most prized resource in a law firm. Brains. You should have lawyers under your roof who can deliver, who can earn money. And the most ideal lawyer who should be very well paid is a lawyer who is able to get clients in the first place. Not a lawyer who waits until the big boss identifies the client, puts it on their table and says, deliver. To me, quite honestly, that's not a good lawyer to be in a law firm. A good lawyer should be able to get clients. And a good leader in a law firm should be that leader who is able to get it out of the juniors, to train them on how to get clients. If you don't have a client, there will be the other resource, that financial resource will not be there. Now, it is difficult to get that lawyer whom I am talking about, for very many reasons. I tried in my firm to see whether I'm getting out of the lawyers in the firm sufficient resources, financial resources, to be able to pay them well and still retain money to run the firm, and of course make profit for the partners. We tried scenarios. We started with a take-home of 500,000 shillings. In order to be able to give your lawyer a take-home of 500,000 shillings, you need to get from that lawyer not less than 1,300,000 and I think something. So you get that lawyer to independently earn your law firm 1,300,000. That way you will be able to pay as you earn. You will provide for office space. You will provide for pay as you earn, service development levy, skills development levy, and all that stuff. Then at the end of the day, your lawyer will go away with 500,000. From experience, no lawyer finds 500,000 good money. So you don't expect to pay your lawyers 500,000. However senior or however junior they are. Even a lawyer from law school does not want to hear 500,000 as a take home, understandably so. Transport costs from office to Kimara will take away almost 1/3 of the money. Your lawyer has appetite, he has to eat. Your lawyer, if he's blessed, he has got 2 kids to take to kindergarten. So 500,000 is nothing to write home about. If you want them to take 1 million, if I remember well, now you are requiring him to pay you, to get you almost 2 million worth of earnings in a month. If you want them to take 5 million, you are looking at getting from them 15 million so that you can knock off these others and they give him 1 million. That's how difficult it is to balance human resource and financial resources. So in a setup like that one, there are even employees who will not be earning you that money. A librarian does not earn you money directly. He gives you support services. So you must take away money from the fee earner in order to pay for that function. So the financial implications of that law firm made in heaven. Get some of the elements from across the aisle from not ordinary. So it's a difficult outfit to set up. Having said so, I'm not saying we shouldn't strive at having a law firm which has all the ideals that Shezaga has given us. However big you are, however small you are, you will not escape ethical issues. You will not escape having to take out indemnity. Because in this world, the real market here, the real market that matters, will not touch you if you don't have an indemnity policy. They will not. They will not even ask you to bid. So you are losing out if you don't have an indemnity policy. You are losing out on the market. You will simply do retail services. Who will not bother whether you have indemnity or not, because the stake is not as high as it is in situations where indemnity is required. 1. 2, whether you are solo or you have to manage your finances. It is no excuse to have no financial systems just because you are practicing alone, and as he said, you take your money, you lose it as you will. So whether you are single, middle level law firm, whether you are the made in heaven law firm, you need to observe the professional do's and don'ts which Shezaga has told us. If you are in a law firm, you need to undertrain the junior lawyers so that you wouldn't like to have a law firm here looking good on the face of it, but when you are unable to wake up in the morning before 9 because of age, and your office will definitely wither away. If the office depends on you and you alone, or just 2 individuals, in most cases all of them very well to the north side of 70 years, you are, that's a recipe for killing your practice even before you go away. Lastly, I would like to make a remark about, this is repeating myself. we must move away from the concept that we have a group of magic circle lawyers who have a duty to teach the young lawyers on how things are done. Most of us who call ourselves senior lawyers grew up in a situation, in circumstances that don't fit into the future. Most senior lawyers will tell you, doing research on your iPad or on a computer, working on the web, to them it looks like laziness. You would rather walk to the library of the High Court, buy himself there, read precedents, come out, make hand notes, go back to the office, burden the secretary with having to transcribe them. We are cut that way. So to expect me to teach a young lawyer on how to do effective research in this world is, I think, having it upside down. As I said, we must be teaching each other. We have things to teach the young lawyers. The young lawyers have got so much also from which we can learn. Thank you very much.
Thank you. Again, you answered my following questions, which was on how you enumerate the young lawyers. You already answered it, because that was the follow-up question. Again, staying on the money side, as we all we are living in China, I would like to be clear with the money part. Are you sort of saying that we should move away from the way we enumerate our lawyers in law firms in the payroll taxes to maybe on a commission sort of basis? Because I know those sort of contracts are not so legal. If you have somebody full-time, then they qualify as full-time employees. And then you need to basically incur this cost. But another point that I'm getting is that we do not only need to teach young lawyers legal skills, because that they know from the law schools, but business acquisition skills. Somebody who's going to be able to earn you a fee that you can actually pay them in time. And on that side, which basically aligns with the size of the market, where is the market for legal services in the country, which we now talk about competition. And I'd like to draw your attention to the cross-border practice thing, the whole issue of having people from the East African bloc coming to practice in Tanzania. I know a lot of Kenyans run law firms in Tanzania, in the name of Tanzanian law firms, with Tanzanian partners, but the equity shareholder in a law firm is a Kenyan. What's your sort of take on this? I could start with Shazada and then we could all come back to him.
So, no, I'll just start with a caveat. From what Charles has mentioned about the law firms made in heaven. So, what I was actually trying to give you as an indication is from small law firms to large law firms, those are positions and teams that you can consider having or not having in your law firm. So it's not a must to have all those people in your law firm, but some of those key people could be helpful in your law firm, but obviously it depends on your financial muscle and resources. We have law firms in the US, in the UK, even law firms that have international presence in Tanzania that follow that structure because they can, and because they are obviously investing into those law firm structures. So that is fine for them. But obviously, a sole proprietor law firm, 1-year-old, 2-year-old, definitely you don't need a librarian, etc. And I'm a very big fan of technology, so I totally agree with Charles that the more virtual, the more paperless you can go as a law firm, that would be the best. And let the machine work for you. But obviously, if you can afford, certain human resources are also very important. Noel, going to your question on cross-border practices and law firms sort of being Tanzanian lawyers or law firm partners being under the umbrella of, let's say, a Kenyan or Ugandan or even an international law firm. In my opinion, I think I am very Tanzanian by heart, and I think I'm very traditional and conservational as well. So a lot of people over the 10 years in practice have asked me, Shizada, so are you affiliated with a law firm in abroad or in East Africa? So I always say no, because it's always been my dream to acquire a law firm outside Tanzania. Prove that we Tanzanians can do that too. We can also have law firms in Kenya and Uganda, and they can be under us. So that has been my thinking, a law firm outside Tanzania to sort of acquire or partner or merge or so with my firm. But obviously, they come with a lot of advantages. Cross-border practices sort of increase a lot of revenue as well for those firms that have taken up these opportunities. I know Muntazir, you're affiliated with Grant Thornton. So one of the best or easiest things is that you will always have a flow of clientele. So you will never have to always look for new clients outside. So that's a good advantage. The disadvantage obviously is that you are supposed to follow a certain protocol and controls as well. We have had law firms be successful in these partnerships, but also law firms that have felt enough is enough. We can't be under you, so we need to go solo again. So my opinion would be, if we can, as Tanzanian law firms, build best practices and be independent, that would be the best. However, I like to encourage associate partnerships with law firms outside Tanzania. So for instance, we work closely with law firms in Uganda, in Kenya, in the UK, and that has worked for us. We've always sent clients here and there in South Africa, and we've always managed a good commission percent or referral fee affiliated with these associate partnerships. I feel that has worked better so that you can still keep your firm and your practices and your standards and benefit from these cross-border practices. So that would be my opinion, and I would encourage that. Let's make Tanzanian firms the best practice firms and acquire firms outside. Thank you.
Thank you for that. Chazi, would you like to weigh in on that? Okay, maybe from your area, Phil, what sort of pitfalls are there in terms of compliance with the taxes for a law firm? Like, our structure is very simple. I finish law school, I get sworn in, there I go, I can start my law firm. What do I do?
Right, yeah, thank you for that. So I think one thing that we want to make clear is that there is no such thing as tax planning, there is only tax payment planning. Because let's face it, only two things are inevitable in life: taxes and death. So I'll take you back to the point I made earlier around having bank accounts. So this is something when we were setting up our practice as well. You know, the constant struggle around cash flows and how do we actually manage that. So what we've done, and this is something that I think was a really good piece of advice that I got, was to have a separate bank account that is only going to deal with your taxes. So the moment I get money from a client, there is a specific percentage of that amount that I'm not going to touch. That goes straight into my tax account, and it sits there. So whenever I need to make my payments for whether it's my payroll taxes, whether it's my monthly VAT, whether it's my withholding tax, whether it's my quarterly corporate tax payments, whether it's the end of year taxes, any tax payment that I need to make is going to come out of that account, and that account will always have money in it. Because the moment I get that money from my client, there's a percentage sitting there. Now, this takes a lot of discipline. It also takes a lot of discipline because there will be times when you need money for operating reasons, and and you're like, well, I don't really have the cash flows, but there's money sitting there, and you got to figure out ways on how not to use that money, and how can you generate money a lot faster so that you can continue your day-to-day activities. So around tax planning, what is really good would be to be aware of when you need to pay your taxes. Because like I said, at the end of the day, we know we have to pay. So what are the key dates in your calendar that you need to be aware of? You know, the 7th of every month where your payroll taxes, your withholding taxes have to be paid, the 20th where your VAT has to be paid, the end of the month which comes in, you know, every quarter, your end of month NSSF, etc., your quarterly payments around corporate taxes. So whoever your office administrator is or whoever is in charge of handling your finances, that individual needs to be on top of when all these payments need to be made. And that way you're also able to monitor your cash flows. Again, from a tax perspective, it's important to realize that you know, our tax laws are not specific for industries, right? They're general. In our kind of industry, the service industry, legal, accounting, etc., you're actually permitted to spend a little bit of money on business development. You're allowed to take your clients out for lunch, for example, and you can claim that as a valid business expense. In our jurisdiction, that's not the case. You will have to have a really strong argument to be able to prove that no, it was necessary for me to take my client out for lunch. So when you're doing your planning for taxes, it's also important to realize that you will have an element of these costs that will be disallowed. So keep that in mind as you're doing that. The structure of a limited company is quite straightforward because that corporate entity will get taxed. But when you're a sole proprietor, it is you as the individual. When you're a partnership, it is not the partnership that is going to be taxed. The partnership is just a vehicle where two individuals, it's like you've got a car with two drivers, right? And each of these are then going to be taxed on the results of the partnership as a whole. So there will be, your payroll taxes, etc., are covered by the partnership, but you as an individual will be taxed based on your share of the profit of the partnership. So in that way, it's also important to keep track of that because your partnership is not required to file a tax return, but you as the partner are required to. So what happens here is that sometimes, this gets forgotten. The partner is actually required to file the quarterly return and pay the quarterly installments on their personal taxes. There have been instances where, for whatever reasons, it has been the partnership that has been taxed and that has gone through. With the updates that have happened at the TRA with the new e-filing system, the system is now a lot more geared towards where the taxes need to be charged and where they need to be paid. So if you're a partner in a partnership, then you need to keep that in mind as well as you're planning for your taxes to make sure that this is being handled well. Again, I would recommend, get a consultant to assist. Tax laws, every year with the budget changes that happen, sometimes there will be a change that happens in the middle of the year. Get someone that you can trust, that you know will give you the right advice at the right time. But also remember that, in matters of tax, as consultants, we're not magicians. Sometimes, you will meet a client who will ask, so personal experience, we had a client who really gave us a scenario and we went to them with about 4 or 5 different alternatives to deal with that particular scenario. At the end of the day, he's like, yeah, but I know all this. So I was like, well, as far as the requirements of the law is concerned, these are the only options you have. I'm not a magician to suddenly just do that and your problem's gone. So have someone who can give you that right advice because that will make life easier. A final point. Try to avoid doing things that will end up in you having to have unnecessary penalties and fines. So one very common point that we see has to do with the filing of returns, specifically payroll returns. Now it's all online. In the past, it used to be manual. Did you know that your SDL return, if you don't have employees, the 4 employees that was there in the past, you still had to file a nil return. So can you imagine how many companies were not supposed to pay anything, they weren't paying anything, but then the taxman would come in and say, well, you were supposed to file a nil return, It's equivalent of $100, 225,000 shillings a month. That was the penalty. So these penalties can easily be avoided just by ensuring that you're making your returns on time. EFD machines. Failure to use an EFD machine, the penalty for that is 4.5 million shillings. So that is something that is just common sense. As whoever your head of finances should not allow you to send an invoice out from your office without an EFD attached to it. And remember, pro forma invoices are not valid invoices. Pro formas can work when you want to put in a quote, for example. But the legal document, the one that TRA recognizes, has to be the EFD verified receipt. So just those few points around how you can think about making your tax burden that you like to.
Thank you very much, Matazi, for that. I think that marks the end of this session because we are running a little bit out of time. Just two final thoughts from Charles. We spoke quite at length about specialization and generalization. How do you build specialty in the legal practice in Tanzania? I know it took you over 20 years that people go to anything mining or anything banking. What's your word of advice to young lawyers in here or those watching online? How do you build that expertise and specialty?
No, I have no magic wand. And I don't have a crystal ball to raise that and figure out the answer for you. But some thoughts, largely from my own experience. Specialization can come, you will find yourself compelled to specialize because there is business out there which is crying out for legal services. And you have people asking you whether you can do. I give an example which I always give. Mrs. Majara, you will pardon me. I always give it, but it's not a bad example. Law firm in the early 80s, I think. And somebody walked into our offices. Somebody we didn't even know very well. To be precise, it was the director of finance of Tanzania'S. Tanzania Oxygen was the first company to be listed on the Dar es Salaam Stock Exchange. Neither Mrs. Majara nor myself had ever heard of listing, except listing in the literal sense, listing things. Neither of us had heard an acronym called the IPO. And this man came and asked us, I think he asked me first, he said, could I help them do an IPO? So I looked at him straight and said, wait a minute. And when this is about the listing. So I walked into Mwanaiti's office and said, do you know an IPO? I said, search me. She said, search me. I don't know what that means. So we asked this gentleman to give us time. He left. We walked across to Advocate Uzanda's office. We asked him what this was. In very few words, he explained it to us and we knew we could do it. There were no emails, were not popular then, so we called this man and said, yes, we can. And we did it. And we specialized in capital markets. That's how we started capital markets. And eventually we had a portfolio which serviced Tanda Cement, which serviced the cigar, I think, which serviced about the cross-border IPOs. We didn't know what IPOs were. 7 years down the line after the faculty of law. But we found ourselves having to immerse ourselves in that sector. And I'm not blowing my own trumpet. I can do an IPO with my eyes closed. So we were forced to specialize. Specialization can be thrust upon you depending on the demands of the market. You can specialize in taxation, etc., because there is a client who wants you to help them. So it can come to you that way. But for the young lawyers, you don't have to wait until it is thrust upon you. There are so many opportunities around here which you can specialize in.
Thank you very much for that. I think the magic will be never to say no to a client. So before we close on this session, I would like to take, if there are any questions from the audience, we have time for about 3 questions.
Thank you, Mr. Presenter and the panelists. I just, when the discussion was going on, this question came into my mind, especially after I heard about the limited liability entities when we talked about it in the standard law firm. We are commonly used to SOL, which is this business name, or partnership. Most of law firm practice in that way. When the presenter was going on in the presentation, and after hearing Mr. Constanza, sorry if I just missed any letter in your name, I realized 2 things. Most of the law firms we have today, they have a number of pending dealings. Like you can be claiming to clients more than $50,000 or $60,000. In T shillings, we talk about $1 million shillings collectively if you combine all the invoices. But it might happen you are at the end of the month or a quarter where you have tax liabilities to pay, and you're cash poor. You have nothing. I would just request this panel and the presenter, how are we going to bridge this law firms or partnership or sole proprietorship businesses which are standing now in Tanzania, majority of us with practice that way? How are we going to bridge this law firm to access banks' facilities, banks' loan? Because I tried once as a job to approach my bank, which I've been banking with them for quite some time. And they said, how do we give a facility to a partnership? I tell them I qualify. You see my cash flow. I have a number of properties here for many years, and you can see my cash flow, how I started. And if it's a security, I'm able to bring a security from one of the partners, and we can sign it. But they were not able to advance a facility, even just an overdraft. It was difficult for them to offer. They said, bring us a proposal, we see. How are we going to assist the majority of us, where at the end of the month we find ourselves with stuck? We don't have cash, but dealings up to 100 million. And you need to you need something to push you up to continue the business. That has been a big challenge, and which I would like this panel to come up with sort of an ideal solution or advise us what we can do. Thank you.
Thank you for that. We can take another question as the panel prepares to respond to that. Are there any questions from the audience? Yes.
Thank you. Let me first thank the panelists for this very excellent presentation and discussions. I just have a couple of comments. One regarding the type of law practice. You have said that law firms, usually lawyers practice in law firms, partnerships rather than limited liability companies. And if there are, that would be very, very few. I think one of the problems that lead to this is the nature of legal practice itself. Liability for what you do is personal. And it's not the firm that will be taken to the disciplinary authorities, the advocates committee. It is you as a person who would have to face whatever consequences of your action will be as a practitioner. And I think that something has to be done there in terms of what are the legal implications of this, and make it a bit easier for lawyers to practice in a limited liability company like the engineers would do. The other thing that I thought I should comment on is the question of specialization. And Charles, I think you mentioned this. I think it's the market that necessitates this. You would have in Shehzada's profile, for instance, a whole list of things, and then you ask yourself whether this is a specialist or a jack of all trades. But if you try, for instance, to be simply a person dealing with IPOs in Tanzania, you will not survive. The market is not just there. And I think it is for that reason that one is required to be a specialist in a few things rather than simply one or two. The possibilities that you could narrow down into a certain area of practice and expect to survive are very, very narrow indeed. The other, my last comment would be on the issue of remuneration. You mentioned, Shehzada, that it sometimes becomes difficult to apply the scale of fees that are available in the remuneration laws. That is very true. Fortunately, we have in the remuneration rules a provision that allows for agreeing with the client on fees. And if you do that, and if one follows your advice that you should have an agreement with the client, then you could have a provision that says, this is the fee we agree. So long as it is not excessive, the law would allow that and recognize it. That is all I have to say.
Thank you very much.
That's the beauty of having a person who moves from bar to bench, then bench to bar. Thank you, Father. And Mutazi, if you'd like to take the question on access to finance.
Okay, thank you. Thank you for that question. So yeah, it's a challenging situation certainly that you did mention, where you know you have particular liabilities that need to be cleared, but you don't have access. Now, so personally, I wouldn't, we've been lucky. We haven't had that situation, but I find it a bit strange to see, or rather to hear, that a bank would not be willing to provide that kind of facility. At the risk of sounding, change the bank. But generally, having worked in a much larger practice before, although not at the role I'm in right now, I am aware that banks were able to provide facilities to partnerships, especially when, like you said, if you can prove you've got a strong business in place, the cash flows are going to come in, it's just tied up in working capital. So I don't really see why there should be an issue. From an experience perspective, I'll let my senior colleagues here maybe chip in if they've had any experience on that.
So I think the challenge is that lawyers sell time. That is the biggest challenge there. And this is why a lot of banks are not willing to give their money to somebody who is simply selling time. No assets, no goods, And again, this is a lawyer you're giving a loan to. When he defaults, you have to engage a lawyer to sue the lawyer. So again, banks are a bit worried, and I don't know why, but people are scared of lawyers. That how am I supposed to sue a lawyer, And especially maybe when you're coming to somebody like Charles, and someone say, oh my God, how can I sue Charles? I can't do that. Charles works with a lot of banks, in fact. So I'm not sure how they would sue him. But I think that's the biggest challenge, that we sell time and we're lawyers. So banks are a bit skeptical about it. I don't think they're saying no because of any specific reasons, because of our financials. but it's simply because they don't know the best way to recover their money. And so, obviously, this will be a food for thought for banks, that perhaps they need to come up with a creative way to structure loans for lawyers. And I know we also tried to get a loan once in our Zanzibar branch, and the bank was very open with us that we need your financials. And I have to admit that we had practiced for almost a year and a half only. We just started our practice in Zanzibar, and we had not prepared financials. So it was our fault that we couldn't provide financials. So one thing that we as lawyers need to know as well is we're not immune to audits. We need to have our books in place. We need to have our financials done accordingly, timely, because the banks want to see in 2 years, is this lawyer making money? But again, they can also see when we are not having the best books. So whereas you're billing 100 million shillings, but you're spending 30 million in disbursements, you know? So the bank asks itself these questions. If he's spending 30 million in disbursements, and out of 70 million is supposed to pay corporate tax, SDL, PAYE, all his employees, etc., what is he left with to pay me? So those are questions that we need to ask ourselves as well. Are we applying best practice in our law firms? And that's why I like to repeat this word. We have to have best practices in our law firms to be able to encourage the banks to give us this loan. But banks also need to consider how to be more creative and innovative to have a mortgage on time. Thank you.
Thank you for that.
Unless Charles would like to add anything? I don't.
Lawyers are risk averse, so I can understand why we don't approach banks that easily. Because we see every day what happens to borrowers who are failed to pay, what happens to their domestic properties. So I personally am very risk averse. I do debt recovery, I do receiverships. I know how much pain I inflict on borrowers. So I wouldn't want a lawyer here coming to sell my property. And that scares me. But there is a facility which some banks are giving now. It's called Invoice discounting. If you have got an income stream, which is very assured, you have a client who has already approved your invoice, but he says our payment policy is 60 days from the date of the invoice. So you have to wait until the 60th day, but everything is assured. You enter into an arrangement whereby the bank will give you a generous portion of the face value of that invoice so that you can meet your immediate needs financially. I will not mention the names because I am not commissioned to be an agent for them. But they ask around, there are banks which are doing that, and they have helped some of us to overcome our immediate cash needs.
Thank you. Consider inviting banks for the next OCON. With that said, I think that marks the end of this panel discussion. What follows, I think, is a token of appreciation from our chief guest, Honorable Judge Ngeta, please, if you don't mind coming to the stage. So Charles will receive the first token of appreciation from Judge Ngeta. Thank you. You guys come on the stage.
Okay. Yeah.
Yes. Shazada doesn't get anything.
I'll just shake hands.
Yeah, please. Yes. have sponsors break. I'd like again to call on stage somebody from Grand Photo. Is it Montasio again? Yes. I will not time to see you again.
Yeah, your presentation is right there.
Okay.
Yeah.
You're not far. I'm not.
Sorry, Mikazi, just before you start, I would like to call all the panels, even those in the afternoon session, to come on stage. We would like to take a group photo with our guest of honor as we have to excuse him. Yes, before you go with the photo session, please, all the panelists, Ben, Kerry, Nashon, Charles, Balozi, Hamza.
Is it the picture?
Yes.
Oh, okay.
You can sit. Thank you.
Moment.
Thank you. Thank you. So please, not allowed to sit down yet, as the honorable judge will be leaving us. If you all like to stand, please.
Thank you. Asante.
As the stage is yours.
Right. Hello, test. All right. So good morning once again. That was just a little teaser about who we are from a global perspective. I would like to say that I contributed to those numbers, but we're actually the new kids on the Grant Thornton block. So just a little introduction about who we are. I'm sure all of you have heard of the traditional Big Four audit firms. Well, guess what? There's life beyond them as well. And we are living proof of that. So a brief history about who we are. I actually started out in one of these traditional Big Four firms. I was in the audit practice. And in about late 2019, we decided to leave and set up our own practice. From 2019, in January 2021, so just a few months ago, network of international firms. And what we do is basically we are providers of audit, taxation, and advisory services. Now, I'm also honored here to introduce our managing partner who is sitting at the back today, Ketan Shah. At this stage, of course, I'd like to thank Stallion for giving us the opportunity to be a part of this conference. Lokon, when we had the discussion with him around what his plans were, we were like, you know what, this is absolutely critical, because being in the professional services field, we know that sometimes, so my mentor always used to tell me that it is the shoemaker's shoes that get spoiled first. That is something I realized when I started out, this practice, and I realized, you know what, I need to be better at how I'm managing my own accounts first before I go out there. So I think this is a very good platform for, to get all the lawyers together and see how you guys need to improve your time. Realize that, you don't necessarily have to do everything on your own. That there are people out there that can actually assist you in making your life a little bit easier. And like we've said on our flyers around, you can see, we target dynamic organizations. And we are all in a dynamic economy here. We're all looking to grow. But with growth, there's a lot of pains as well that come in. So what we do is, we like to say that we're part of a global team, but we give you that local touch, that personal touch. We provide services to clients that are across a wide range of sectors, but at the same time, knowing that there are specific industry-specific factors that affect each particular client. So I like to say we take time to understand what client needs are, and then give our feedback and our advice based on that. Between us, Ketan, I'm sure most of you, if you haven't met him, you would have at least heard of him. He's been around in the professional services field for a lot longer than I have, which is why he's senior partner. But I've got my eyes on that. Just don't. But yes, so between us, we are we set ourselves the highest possible standards. That at the end of the day, we would like our clients to walk into our office knowing that any concern that they have that relates to the financial services space, that they can deal and speak to us, and we will be able to deliver to them on that. And so what we do, audit, we talked about this, we alluded to it a little bit earlier in the panel discussion, but audits are actually mandatory. When you're going to be filing your statutory, your annual returns, you're supposed to put in your audited financial statements in there. So obviously that is a key service that we do provide. Ketan and I are both accredited with the NBAA as certified public accountants. Situations that need that particular additional expertise. There we go. And in those circumstances as well, we are available. And then advisory, which covers quite a wide range of services, and we've put them again on our flyer. So we've got your accounting services where we handle your back office. You've got your deals and advisory team, your fund management team, accounting support, payroll support, global mobility. So even if you have global tax issues where you're looking to bring in expatriates from outside, and how do you actually make sure that you're complying on taxes in all the jurisdictions that you're going to have a presence in. So in a very brief nutshell, that's what we do. It's good to know the people behind there. I've taken off my mask. I think that's reasonably what I look like as well. So we'll be obviously available here for the rest of the day. Do feel free to reach out to us. We've got our business cards loaded today. And it'll be free, it'll be good to catch up at some stage, even if it's not for legal advice from your side or accounting advice from our side. We can just meet up and have a cup of coffee. Our offices are at Viva Towers, so if you're ever around in that area, do pop in, office 207. Once again, a big thank you to Shehzada for letting us be part of this, and a big thank you to you all as the audience for listening to me. Thank you very much.
Thank you very much, Taji. Thank you for having us here. Truly our power sponsor. So next up is our second panel session, but before that I think we have a keynote speaker, Balozi Mwanaidi Manja. I would like to introduce Shehzada, who's going to be the moderator for the second panel, and introduce you.
Thank you, Noel. I think when the name Ambassador Mwanaidi Manja comes to mind, there is no need for introductions. But when we asked her for her bio or introduction, can you imagine this is what we got? Mwanaidi is a graduate of among East Africa's finest universities, the University of Dar es Salaam. Currently, she is the chair of Rex Advocates, a Tanzanian premier full-service law firm. She currently heads the law of natural resources, which covers energy, oil, mining, and gas at Rex Advocates. Mwanaidi is also experienced in corporate law. That's it. That's what we got. From, I call her Mama, so that's what we got from Mama. How humble is that? So thank you so much for that, but I think she's a lot more than that, and you would agree with me. So, Mama, the podium is yours, and we're here to listen to you. After this, we will have a quick panel discussion, and then we can all wrap up for lunch.
Sorry. Nisame. Mimi mtu mzima. Good morning. Morning, everybody. Morning, Shehzada. Thank you very much for this opportunity. When I was asked, I immediately took the opportunity because I like talking to fellow lawyers and also learning from others and sharing what I have accumulated over the years. I'm happy I have my colleague, Honorable Fauz here, and Nancy from Rex. And I'm also happy to see my friend from Thornton, Grant Thornton. We've known each other for quite some time. And Shehzada, you've done a favor to many lawyers here. It's good to bring these professions together. I cut my professional teeth not in a law firm, but in an accounting firm. And I think there's a lot to share between us, and maybe in the next diversity conference organized by the Tanganyika Law Society, maybe we'll participate, and I think many lawyers will benefit from working closely with the accounting firms, because we need you as much as you need us, but I think we need you more. On the subject I am going to talk about is a subject that isn't really much discussed amongst lawyers, but it should, especially because a majority of the legal practitioners are solo practitioners, but now it's urgent because of the pandemic. We were shocked in our annual general meeting of the number of the lawyers we had to commemorate and to pray for those who have departed. And when I got this subject, and as I was doing my research, I was thinking, who is actually closing those law firms of the lawyers who departed? Who is taking care of the client's business to try to transit it? Who is taking care of the few maybe young lawyers who were employed by these people who departed? And I think it's time for us to start this conversation. And Charles talked about this circular which is going about from the Council for Legal Education. You read the things they want to inspect, and there's nothing about succession. So I think I want to thank Shehzada for bringing this up. It is very timely. The context doesn't actually refer to all the slides that I'm going to talk about. It's only showing what will be covered in the presentation. What is succession planning for law firms? Lawyers always want to go, what is an IPO? Asked. So succession planning, as far as I'm concerned, it has a multiple definitions, but it is simply a plan for the passing on of the baton, or a plan for closing a practitioner's office affairs when you're solo. I looked at Wikipedia. Charles, we also do that. I looked at Wikipedia. It's a process of identifying and developing individuals to succeed senior positions. That is if you're a partnership, if you're operating as a limited liability and you have many employees. Investopedia says it's developing new leaders who can replace old leaders when they leave, looking for greener pastures, or when they retire, or when they're incapacitated or die. That's the plan. Black's Law Dictionary, which we used to do when we didn't have Google, it is an act of a right of legally or officially taking over a predecessor's office, rank, or duties. That's the succession plan. And predecessor meaning if you passed on, that obligation of taking over the rights and duties. So successful legal practice is based on strong credibility and goodwill of established practitioners who have been there for many years and has established relations, clients who respect them, solid foundation. Now, how do you pass that on? Kama mimi sasa, how do I pass it on to Nancy, who is a young practitioner growing up? Dr. Faust, how does he pass on his experience? Charles, how do you pass on your experience? In the law firm where you are, let alone kwenye bar. So it's the continuity of your firm and the practice depends on the succession plan. It may be formal, it may be informal, it may be happening, but how do you deliver that? Coaching, training, mentoring, developing talent that are within the practice for those who are partnership, and the ability to be able to be like you. Because it's not about machines, it's about people and skills. We know of so many firms that died with their founders. I don't need to name them. You know, the founder is incapacitated and the practice is normal. The founder is dead and the practice is normal. So how do we sustain practice? In a succession planning, what do we do? You pay special attention to what? Because the stock of a lawyer is time and the people that work with you. How do you develop them in the leadership and how do you groom them? That is where you must pay attention. We don't seek professional guidance. Murtaza told us we need to seek professional guidance on tax matters. HR resources too. Shehzada talked about Tanzanian law firms growing and acquiring law firms outside. You need to have the capability and the resources to do that, and that is the human capacity. So we need to get professional guidance that will provide the planning, the tools to deliver the succession plan, to monitor, and to manage the succession plan. We don't know everything. Sometimes we've got to hire consultants, and Shehzada said so in his presentation. What is it? It's not only foreclosing the practice. Foreclosing the practice is when you're dealing with a solo practitioner. It is meant to guarantee continuity, that the firm can survive you. And actually that has always been my dream, that the firm we set up can survive me. It doesn't have to die with me. It's about retaining talent, grooming and developing capable practitioners with goodwill close to the seniors, creating second and third tier of practitioners and the right leadership to continue the firm's growth and possibly, of course, to take it to another level. And how do you do it? How do you develop that? It's about retention. We're talking about compensation to practitioners. And what are you offering your practitioners? Do you just pay them their take home? You don't care about their health and their family's health? Do you provide insurance cover for them? Do you provide life cover or incapacity cover? Do you send them to law firms that are friendly for them to learn? Do you send them to workshops, to discussions like this so that they can learn and they can acquire skills? Do you show them the opportunity to stay on in the firm and to learn and to aim higher, to want to stay with this practice rather than going elsewhere? It's about policies and procedures to ensure client practitioner protection. In the event of departures, when a senior partner departs because there's a disagreement, maybe, there's a dispute, maybe, or I want to retire now, or I'm incapacitated. What happens to the client's business? Do you have a system that people will know the client that was being handled by Mrs. Maja can be taken over? How do you keep the client files and information? We will see below how we are going to do. So it's about those policies and procedures and how you want to manage departures. It matters. It's about policies and procedures for record keeping and archiving and handing over notes, whether you're going on leave or whether you're going to retire or whether you're leaving. We call in our firm handing over notes. You're going on leave, you've got to write handing over notes to your colleagues, describing the client matter, describing what is pending, describing where you're arriving, describing the contact person to the client, and where the matter stands, and where it is filed. Is it in the O drive? Is it in your own desktop? Where can it be reached? So there are a lot of benefits when we're talking about, and we will describe more the procedures, but what are the benefits for that? It protects you as a lawyer. We know lawyers who have departed and clients or creditors went after their estates because we have no limited liability. So you're protecting yourself when you're planning so that when you're not there or you're not capable, there is someone who is going to hand over the matters and manage the process of your unavailability. So that protects you. It ensures continuity of the firm and the business because many firms do not outlive their founders. It protects the clients, their matters and their payments, money, clients' accounts. You heard about clients' account. Those are protected because there is someone who is taking them over, someone who understands them. It protects the information of the client, the files. How do you keep the physical files? How do you keep the digital files? How information is kept, and how the client can continue the matter after your departure or after your death. That we don't have a system in this jurisdiction, and Dr. Fauzi has noted in his book, The Legal Profession in Tanzania. He noted cases where advocates died, and that's many years ago. We haven't been able to rectify the situation, and clients couldn't recover their records or their money already paid in advance. Even now, that is happening with lawyers that have passed. So when you plan, you are actually protecting yourself and you're protecting the client's matter and their money. How do you build the succession plan for law firms? I'm not talking about an individual law firm here. I'm talking about solo practitioner. I'm talking about partnerships and those who are practicing as limited. It starts from beginning, by the way. Sometimes you're cautious, sometimes you're not cautious. By the type of partners and you choose to partner with, and the type of associates that you're recruiting, actually at all levels. That is where you start planning. You're having to focus in a certain area. And then there is the training and coaching and mentoring and exchange programs and practice development plans. Now, we do training in our practice every Friday. Even today, there will be one at 2 o'clock. That is one. You are training your practitioners in the skills, legal skills. We are doing arbitration now, which is very important because of the new Arbitration Act. We did the beneficial ownership requirements under the Companies Act because it's a new requirement and there's a time frame, and so that our practitioners know what to deliver and what to do with the clients. So these are the coaching that you do. You coach your teams on how to actually do the legal work. And then also you may have exchange programs. When we were with ENS, we used to have this all, but also there are exchange programs with friendly law firms like Allen or Overy that come out here. You can encourage your practitioners, and the practitioners should be on the lookout to see. And then you can do other development plans as you may consider necessary. You undertake the formal and timed performance assessment. That is a very challenging area for lawyers. Assessment of your teams. How are they faring? Who is doing better than the other? And it may be formal, it may be informal, but you have to do an assessment. And then the practitioners also have to know there is a transparent compensation arrangement and also a way of retaining skills. Those are the best that you don't want them to leave. How do you remunerate them so that they stay? In Rex, we know, and Charles knows, we create, we train, and then the richest situation, you don't realize how far you has gone, and you don't elevate them, they leave. The market still can absorb those who leave and go and try to start on their own. So they leave. So Rex became the training law school for many of the young offshoots that we see out there. So when do you recognize that your trainee is ready to go up? That is something. And that has always been a challenge. But also the clear path to partnership, that someone can count the years and what she is bringing in or he is bringing in and assume now I can apply to be partner, or I can start demanding quietly or surreptitiously, anyhow, to be elevated if they are not watching enough for them to be elevated. And then you need also to identify the best. Who is the rising star among your teams, and how you want to prepare them? Do you want to let them know that they are actually being prepared to take over? Those are some of the ways you can create the second tier and the third tier in your firm so that you can have people who will actually take over the practice when you're not there. I can say with confidence that I think we have people who can take over in Rex when we are done, we are gone. So as I'm saying, it starts from the beginning, but you can start now if you've not formalized the process. You can identify the complement, the experience, the partners that complement your experience. You can hire also laterally. Talk to the practitioners at your level that you think, why don't we team up together? I mean, if you want to build a big, capable Tanzanian law firm, you've got to do that too, lateral. lateral hiring, you can also identify skills needed to have practitioners, and you can hire them, new ones. And you can also do intel on the competitor and pick the rising star from the competitors if you get the appropriate intel. And then you can actually grow. And so, but also look at the nature of the compensation that you're giving, and that is always a big challenge. Because when you offer compensation in a way that it's a monthly, it requires continued income, and that may be a challenge. But if it's a question of profits, it may be easier because you take what you can, what you have, and what you don't have. When you do a practice of salaried partners and practitioners, that is when, my friend, you have a situation where you have to go to a bank. We've done that many times. And the banks will give, as long as you have your books of accounts that have a history. If you don't keep proper books of accounts and you don't have audited accounts, the banks will politely say, we don't give lawyers, but they actually give lawyers, and we always go to the banks and they give. And then establish the policies that, for example, how do you receive new matters? In a way that is transparent. Conflict check, matter number, which is shared by everybody and kept by the accounting office. That will ensure that you're not there, everybody knows this client's matter number is this one, this is where we stand. And then the recording. Storage of clients' information. Physical files, the registry, who is maintaining that registry, the numbering, he was talking about color coding. How do you identify your files? And then the access of and sharing information. We have what we call O-Drive. That is where everybody can go and get, and makes life easier, because when you're doing a contract, you can go into the O-Drive and you will get formats there. So how do you keep that information there so that every practitioner can actually access that information? And how do you create, when you have a major client and you're doing a due diligence, you can create a common file where everybody can access, which means that client is not dependent only on Mrs. Maja. Mrs. Maja amegongwa na gari huko, Mwenyezi Mungu apishe mbali, mnaendelea bila shida yoyote. So, ikiwa sasa file ni siri yangu mimi, ukigongwa gari na file limegongwa gari. And then the succession planning, and I can tell you many are doing that as unconsciously, is the managing transitional client and other information. Ambayo inakuwa based on formal protected storage of record, physically, digitally, nimeshasema, OneDrive, nimeshasema, filing registry where all practitioners can access information. You can always, and there's a registry keeper, you can always say, si tunasema, we Edgar uko wapi? Ebu tupe file number so and so. Or the chief accountant, what is the matter number? And when you're billing, you know the matter number. When you're giving your time, it goes into the matter number. So it's uniform, kila mtu anaona. Then the handing over information and instructions about access to registry, computers and protection. Kama kuna password kwa a certain matter, that password anakaa nayo nani? Who keeps it? Is it the chief accountant or ni nani? Information concerning the firm's accounts, liabilities, clients, trust account. Tuna finance partner, lakini kuna accountant. So whether the finance partner kagongwa gari, Mwenyezi Mungu apishe mbali, accounts tunazijua. The chief accountant will be there. Information about firm's management, statutory compliance, na licensing, na taxes. There's the account, chief accountant, lakini kuna account information. Details concerning contact person. Kwamba, if I am working for client X, usually kwenye engagement letter itasema the contact person hapa ni fulani, lakini kutakuwa na another second contact person. So that one contact person is disabled, the other contact person, your client will always reach information. Lakini you have also the support secretaries, ambao walikuwa nazungumza wali. There are secretaries who are copied in every correspondence because they are actually keeping record of the client's matter. So the client will always know where to go. Hiyo yenyewe ni part of succession plan. Details the relationship. Who is the relationship partner or senior associate? It matters a lot kwa sababu those are the people who will be accessed in case of need for succession. Solo practitioner, information will take over practice. Information requires about who will take over the practice in your absence, and where there's going to be a slide on that one. That is very important. Kwamba wewe unakaa ofisini kwako peke yako. Sasa wewe ukagongwa gari tunafanyaje? And other jurisdictions kuna requirements ya information kwa client, and I will share that. Succession plan, nimeshasema tena, it is about training the successors, preparing them, grooming them. That is what you're going to do. Assess the skill gaps, ambayo we hardly do, but you know that what you know. If you have departments like we do, you know which departments need to be developed. But also kuna wale practitioners ambao wako proactive. They want to actually develop themselves in a certain area of practice. So you can see, pamoja na kama anakuja chambers and partners, anakwenda na participate because anataka kujijenga kwenye certain area. Or they do articles, wanaweka LinkedIn, wanaweka kwenye website because they want to develop that. Help them to do that. Hizo placement imeshazungumza. Development training kama CLEs, Tanganyika Law Society, make sure those that you want your practitioners to participate in, unazipiki kama hawaoni, maybe you can encourage them. Internal knowledge sharing, when you're handling a matter, important matter. When we create the teams, we don't only go for the teams that those who understand that particular matter. We put in a whole range of all the practitioners mpaka kule chini kabisa. Now, unapo create the team communication, wanakuwepo, so they see and they learn what you're doing at that particular matter. Now, wakati mwingine it's good to expose them that way and to discuss these things when they go inakwenda. You may identify an internal coach, but sometimes when you do it, you're not doing it kwa kusema kwamba wewe ni coacher, but every associate is reporting to a senior associate. And senior associate is reporting to a partner or to a junior partner. So in that way, you are mentoring and coaching all the time. Now you are exposing them to the things that you're doing all the time. So that succession plan, whenever you prepare, is actually to be able to hand over matters without avoiding chaotic handing over matters. So we should prepare a succession plan ambazo zinakuwa formalized. It may be happening in your practice, but you need now to formalize it in a way that everybody knows it's actually happening and you're doing it. And the thing is, of course, it requires a lot of time. Practitioners, we struggle all the time with doing things other than attending to clients' work. Even when we talk of assessment, I can tell you the reality. We would set a date for doing assessment, and that date may go past before we actually do it. You may set a date to prepare that document for succession plan, your date inapita. What happens when you meet as partners, you keep reminding yourself, we have to do this, we have to do this, and that is very important to do. But I talked about getting expert advice. I think it's very important. What I can emphasize here, ni kwamba succession plan is not an option. It is important for your survival. If you don't have it, unajiumiza tu mwenyewe. In other jurisdictions, it is mandatory. Sisi hatuna mandatory. Kwa hiyo nitakuja kuongea baadaye why we need to make it mandatory. I am talking about succession plan for solo practitioners kwa sababu wao, it is actually succession plan when they are not there. In other jurisdictions, it bars in our oblige for them to do succession plan and to include the name of the advocate ambaye atakuwa ndio successor wako, atakaye close your firm. If you are disabled or if you are dead, you have to have that. And I looked at the American Bar Association, the National Bar Association, some other state associations, bar associations, na zote, na UK, they all contain mandatory succession plan, ambayo you must actually tell your client in your engagement letter or in another contractual arrangement that if I'm not here, the law firm of X and Y advocates or attorneys will give you information about your matter. I saw this happening many years ago when I was a very young practitioner, when an advocate passed on. And I remember a senior advocate, Javeri, for those who remember him, was assigned to actually go and fold, signed by the Tanganyika Law Society, to close the affairs of that. And but I have seen here, when solo practitioners die, you find their relatives trying to come in and try to close that, and it becomes very chaotic because their relatives who are not even advocates, practicing advocates. So it's important, and now it is very, very important to have a plan as a requirement. I saw the Council for Legal Education long list of their inspection. Thanks God they are asking us to comment on it. And there's nothing about succession. There is only a lot of things which don't even matter to lawyers. Na hiyo Ale Charles alizungumzia kuja kuhesabu kama watu wana vitabu, which is long overtaken na events. So I think we need to comment on those rules that they are circulating to tell them, you know, this is what we need more than that. Now, Tanganyika Law Society also has to look into that. So I was talking about no mandatory succession planning in Tanzania. Here in nimeiona, there is no formal mandatory succession planning, but it is critical because many advocates are also solo practitioners. Section 57 of the Advocates Act deals only, sorry about that misspelling, it protects only payments to advocates who take on matters from deceased advocates, but no protection for clients. And this was also observed by my colleague, Honorable Faust. Section 7 of the Advocates' Professional Conduct and Etiquette Regulations deals with consent of former advocate prior to successor advocate accept instructions inter vivos, not even after the advocate's departure or disability. Without succession planning, succession of firm closing becomes chaotic. Kama tulivyoona nyingi tu, na mifano ipo. I was talking to the young lawyer there, siwezi kutaja majina, a chaotic closing of a very famous lawyer. Ambao utaona kabisa the firm, in extreme cases, the firm of course they collapse, but the victim ni nani? Ni clients na employees. Do clients worry about succession? Unajua, unsophisticated clients mara nyingi who don't even know how to get a lawyer or pay, they really don't know kwamba kuna succession. But sophisticated clients, they know, and they want to know about what happens when you die. And I was told on my face, well, before I had partners, kwamba I'm hiring you as an exception, but we don't normally hire solo practitioners kwa sababu tunaogopa ukifa. I said I was not about to die. He said, who knows? So we're saying who should take responsibility ya kufanya succession mandatory. Council for Legal Education, because it is provided for in the law, the Tanganyika Law Society. What can they do? So I'm saying develop succession plan policy and rules. Bar associations globally, they do that. Require mandatory compliance by law firms. If law firms don't self-regulate, this will be imposed by law, kama vile mnavyoona tunavyofanya. Develop succession plan formats na monitoring tools ambazo lawyers can actually pick on, and I saw that from the one of the American states, where they have a model planning ambayo inaweza kuwa adopted by law firms. Unaijaza, unapeleka. Like also for them, the indemnity insurance requires you to have a succession plan. Maana wanaogopa people can come after them. Sasa sisi hatuna chochote, na bahati tu ni wateja bado hawajajua, wakili wangu kafa, mimi hata sijui nifanyeje, mafaili yangu hata sijui niyapateje, na mimi nilikwisha kumlipa pesa, inakuwaje, wala hajui pa kwenda. And I think these things ni vitu ambavyo vinatuchafua sisi mawakili kwa kweli. So na sasa ni wakati wengi tunaondoka very very fast because of the pandemic. Kwa ni wakati wa kwanza kuangalia kwamba tujitengeneze, tujiweke vizuri. Na Council for Legal Education should monitor and evaluate compliance through annual reports or other statutory reports. Kwa mfano kwenye audit, kama you are audited, there must be statutory mention kwamba you have a succession plan ambayo ipo especially for solo practitioners, wale ambao wako partnership at least someone knows where to go and what to do. Kwa hiyo hizi ziwe kuwe na requirement. I was just saying, showing where I got some of the information, because it's not anything that we have, and you can see that. And that's about it. Naweza mkauliza maswali.
Thank you very much.
Na washukuruni kwa kunisikiliza.
Mama, we will now welcome you to join the panel for a brief discussion and some Q&A. So if you can just take a seat on the chair next to you. On the panel, we have, because this is a very interesting topic, we decided that we're going to bring on some young lawyers to join the panel, so that we can put them in the hot seat and understand from them what are also their expectations.
I should say.
Yeah, so you can have a seat there. The first person on the panel, his areas of interest include cyber law, corporate and investment law, contract law, arbitration and banking law. As a credible professional, he believes in delivering results and client satisfaction. Over a course of time, Hamza has been involved in various international arbitration processes in and outside the country. He has also been involved in the transformation of the NGOs in adopting the theory for change in Tanzania. What a great thing, Hamza. And joined by him is our next panelist, Mr. Isha Bakaki. That name has been difficult for me to pronounce the first time I read it, so forgive me for that. But Isha Bakaki specializes in corporate law, telecommunications, and ICT law, banking and finance law, capital markets and securities law, tax law, and non-for-profits. He possesses broad experiences on contemporary corporate and commercial issues, revolving around mergers and acquisitions, tax compliance and transfer pricing, corporate management and restructuring, project facilitations and business planning, corporate real estate, insolvency management, and dissolution of companies. Truly, what Honorable Judge Fo said, if you specialize in one thing in Tanzania, we will stay hungry. Isha Bakaki has basically covered everything. So, welcome Isha Bakaki. While the panel discussions are going on, I encourage you, if you want to have a cup of coffee, tea, you can just stand up, go grab a cup of coffee, sit down. We have coffee and tea throughout the conference, so feel free whenever your stomachs are calling out for something. See, Mama's grabbed hers. So this topic is a very interesting topic in the sense that we have a lot of young lawyers that have been crying out to the senior lawyers and law firms by saying that, how are you supporting us? How are you empowering us? How are you making us feel wanted and nurtured and so on? So my question is that we have seen many law firms come and go in Tanzania. In your opinion, what is the biggest challenge when it comes to grooming and training lawyers at the firm to become partners or leaders? So what is the challenge that you're facing in grooming these lawyers? Because it's very easy for a young lawyer to say, I'm not getting the opportunity, or I'm not getting the right training. But I believe that law firm partners and law firms also have challenges in training and grooming these lawyers. What is, in your opinion, the major challenges? So if you could please take like 2 to 3 minutes only in answering my questions. I will start with Mama.
said it. I didn't? Anyway,
So
let
what
me
are
say.
the challenges?
Okay. Challenge. Number one, grooming lawyers happens all the time because really that's why still in other Commonwealth jurisdictions you will hear about apprenticeship because you're learning by doing. So you are working on a team with a senior who will actually be guiding you, will be showing you what to do and grooming you. And so what happens is, it depends on the setup, but generally in RECs, since many years, we would have associates and senior associates, and these are the lowest legal officers before they go through the law school. But generally, we start at the level of associates. Now, you have to discuss with the practitioner what area they want to do. Some want to do litigation, some want to do corporate, some want to do general criminal practice. We didn't have criminal practice until 1 year ago when criminal practice was almost necessarily thrust on us because our corporate clients were being charged with criminal conduct. So you train them by doing, exposing them to the area of specialization, and of course, depending on the practitioner, you can see how they are developing. And some develop quite very fast. Problem is, it may take too long for them to see they want to be partners very quickly. And you're calculating and saying, you're not yet a partner. And the biggest issue that would delay a partnership is you can do the job, but you're not at all getting out there to be able to bring clients. So you and we've met people partners who never had the client coming at all, or maybe one very far apart, and that is the challenge that we have. So that trainee is unhappy because it's not advancing, and you are unhappy because you don't believe it's time for me to be sharing with you yet. You've got to do a little bit more. How we deliver that, that's something else. Are you doing during the assessment, are you going to tell them point blank that you know you're not going to advance into partnership here? That is a big challenge. So in the end, they leave. And sometimes people leave and they make it elsewhere because there, maybe they felt too comfortable and they didn't want to do beyond what they do, or maybe they felt intimidated, or maybe because he is operating in a place where the overheads are different, or the way he is building himself is different. He is a bit better than when he was with you. Whether he can sustain a practice into growth, that is something else. So that's the biggest challenge. And the other thing is the trainee themselves. There are so many opportunities at the moment for them to grow, rather than depending only on the apprenticeship. Is that a trainee really picking up and doing? Do they want to work and be asked to work, or they're just looking at what they can get at the end of the month? So this is the challenge.
Thank you. So wanting to become partners very fast. Hamza, what is your take?
Good afternoon. Good afternoon. Good afternoon. It's a very interesting topic, and I stand before so many young lawyers, because I'm a young lawyer, I'm representing them. I have experience of doing the same thing like this, what Mama was saying. But for me, I can say that in the law firm, if you look and you'll be witness that for the past 4 or 5 years, as of now, the professional, has been tremendous, got some challenges. You find that, as I said before, the firm are coming and going. That means they're collapsing, coming and going. So you'll find that most of the law firm in Tanzania was depending, most of assignment from the government. So you find that during the time, the government themselves, as you say, they've set up this Solicitor General, the chamber, and then they've been pulled out all the cases, all the assignment from private advocates. That means from today onwards, we private advocates, we can't access or we can't get some assignment from the government. There is a gap like this one. So you find that in the law firm there is financial constraints that's frustrating the senior advocates. And at the same time, because before they got a lot of money from the government. So from that point, they struggle with themselves. They're stressful with their life, They don't get time, just to train this young lawyer in the law firm. And sometimes we find other young lawyers in the firm as an intern, and they are not eating anything from morning up to evening, some law firms. Another thing that we need to understand, we young lawyers and our senior here at we're the one who are working too much. They're giving us a lot of assignments. We're making research as a scholar, and we see the inputs from the clients. We find that the law firm has got millions of money. I'm a young lawyer, I don't have a car, I'm not living in a good place. I need also to sustain. They need to think about it. Unfortunately, the money is there in the account. You see? At the end of the day, you find unfair distribution of the firm cake. Every day I'm just waiting for. They will call me today. The day is ended. 1 month, 2 months, no money. The bill distributes themselves. They're seniors. What should they say? Do you think that I will be happy continuing with them as a successor during the session plan? I won't be happy. That's the reason why you find the firms comes out. And they don't, most of the lawyers, they don't think that at the end of the day, this practice will end. We don't think so. And we as an advocate, we don't discuss about this issue Mama said about succession. We don't think that will die at the end of the day. The same advocates, you find that sole practice. You go to the firm as an intern, the owner of the firm is only solo. And he's the one who trained you about how to partnership. You are asking so. Yourself, you didn't make it. You're training us to find a partnership. How can I make it? Another thing that we young lawyers, we see from our seniors, there is a gap between the young lawyers and the seniors in the firm. How will you explore the experience from the senior? So this gap makes most of the firm not to go on. You find most of the firm, as of now, as I'm saying here, a lot of firms have been shut down. Big firm. You see? So this is the kind of things, this is the kind of challenges the jurisprudence has as of now. And if you look, you find that there is a lot of law firms, much more than say. Most of the young lawyers, they have decided to open their own firms. Why? You have to ask yourself. It's because of the challenges which brought in by the seniors. If when I graduated and finding the things are well, organized, I couldn't open up my law firm. I have experience about maybe I can say 10 years, just looking to see what they do. But I have a law firm, obviously, it's about 3 years. I'm just feeling better, not mine. I see what I'm doing. But I think then that I get experience. Most of the law firms we find during the time, those days, they didn't comply with the legal requirements. So I don't think that will find this law firm will shut it down. It's because of the compliance issues. They earn a lot of money all day, they spend all the money. Today, TLA needs the money. They don't have money. What to do? Just to shut down. You see? This is a challenge that we have today in the jurisprudence, but we have learned a lot from the seniors that we young lawyers, when we establish our new law firm, we need to comply with the legal jurisprudence if we want to sustain. And because we've got an exposure, we are planning also for succession. As established this service legal, I expect, even if tomorrow I die, somebody else will take off. Because I have a very good example. The big law firm in town, they are no more. You see? If today you talk about some law firm, they are not there. My law firm becomes big law firm, and that law firm that I made with, which has got a lot of assignments from the government. If you go to EOT, you ask, they say that before, this was the one who had been assigning the cases from the BOT, from TLA, all the big and mining sectors, but they are no longer existing little present. They are dying literally. Thank you very much.
Thank you, Hamza. So what I'm hearing from Hamza is that basically lack of appreciation towards the younger lawyers is probably a challenge. I just want to give you sort of a question here, because you really touched something very sensitive. When Charles was talking about if I am going to give you 500,000 shillings, you need to be contributing at least 1.3 million shillings. So when you're talking about equal distribution of the cake, don't you think that the young lawyer trainees should also prove it to their firms that they are capable to bring even one client, even if it's just a notary public client? So what is your opinion on that? Like, is it something that you've looked into, or you think it's correct?
If in the mind you shows and say that unfair distribution, I didn't say about equal distribution. I know how much they are senior. But when saying unfair distribution, that means, I have an assignment. I'm the one who are in and around. I'm just working. You at home. You've been assigned me. And they came to me like that. We've been paid $1 million. What is my expectations? You've been paid. The assignment that I've been done myself. I did a lot of research. And they know that I've been paid $1 million. What is my expectation? That is my concern. So from that point, you find that a young lawyer learns something in his mind. And this kind of young lawyer will never stay longer in that law firm. He will think also to have his own. Mama says, if you treat a young lawyer in a good way, you see, you find another thing is, when money comes, these seniors, you don't find them in the office. If you ask, you have a meeting, they don't want, they're busy all the time. If the money is not in the account, they're in the office from morning to evening. That's a challenge. So we learn from them, and we know the situation.
All right. So that's very interesting. I think it's a very hot thing here. But I believe the audience will also have something to contribute. And after Shabaki, you've given your comments, I'll probably get Mama to give a small comment on how that's concerned. So what do you think about, what are the challenges of grooming younger lawyers who want to become big partners and leaders? What do you think are the challenges?
Thank you. Thank you. I think first of all, before we discuss this topic, we need to know which kind of law firm are we talking about. Is it a big law firm, a medium law firm, or a small law firm? But for the purpose of my today contribution, I think I'll focus on medium law firm and small law firm. One among the, because there are the laws here in Tanzania, and one among the key issues which I would say, number one, is on retention of talent recession. Because most of the law firm here in Tanzania, especially medium law firm and small law firm, we are using the approach of what's called lockstep approach, whereby the seniority in the law firm will give you more benefits. For example, if I join a law firm today and then I found someone who is very senior, will be paid more than I do, even though I'm a talent there. So I think that's one among the challenge. And number two is career path. As Hamza said, you will join a law firm and then you'll be performing well, very well, but there's no career path. You don't see where will you be tomorrow if you perform best. And then the other key challenge, which of course Hamza addressed in a way, is the problem of lockstep approach, whereby you pay those who are senior is that if you just get a young brain who is both a brain in terms of talent, but also a brain in terms of rainmaker, you may find that he or she cannot save, the future in the law firm. And that's why you find a lot of these junior lawyers, they will run out the world, they establish their own practice, and at the end of the day, they'll become successful because they got all what it takes to have a law firm. They're big, they're good brain, they are the rainmaker, they know how to connect, how to get clients. So at the end of the day, that's why you found that there's a lot of new law firms which are coming and which are very good, which are also taking over big clients. And this is because, I may say, the old law firm failure to acknowledge talent retention. And when you talk about talent retention, it's not about career paths. You have to talk about a lot of things, like bonus. Do you give as much? What are the percentage you will get if you participate in a certain project? Because for instance, if you pay an associate, let's say 2 million or 3 million, and then you are in IPO project which you be given, let's say 100,000, and then for you, you end up paying that an associate a certain salary, he or she will not be happy because you have performed an undertake, and bad enough, he or she is the one who invoiced that client, and then at the end of the day, it will be the partner who wrote, perhaps Mercedes-Benz, and then not even talking of appreciation for that associate who helped you. So my advice for the coming law firm is at least to have a bonus policy, whereby, of course, someone has a salary, but you appreciate a person based on the task which he or she has performed. And this is not just a normal bonus, it's a performance bonus, but also a normal bonus like that. And then the last issue, which I see is a challenge, is a trust issue. And that's why you find a lot of law firms here in Tanzania. I never saw a law firm which has more than 20 to 30 people. Not compared to admin, like a librarian, no, I mean like partners. Who can mention to me here in Tanzania a law firm which have more than even 12 or 10 partners? It's impossible because trust issues. And trust issue will start from recruitment, from training, the trainings we are doing, from having a meeting like this, open meeting, which we discuss issues like this. And that's where I think for me, I found the problem.
So, Ishabakaki, very, very interesting observation. Talent, retention, you're speaking of bonus. Probably 2 or 3 are brilliant minds. So what is your message to those who are basically not performing so well and are yet complaining?
Exactly.
Because I can't imagine that all of them are the best performers. So what about those? What would be your message to them as a fellow young lawyer who now is a partner?
And that's the thing which Mama spoke about. I think we need to have that tendency of doing performance appraisal. And most of law firms, they don't do performance appraisal because it is from performance appraisal whereby you determine someone's salary, whether we go high or we go low. It's from the performance appraisal which will determine someone's career path, whether it's going up or it's going low. So it's just to be open. If someone does not perform, say this is not a firm culture, and that's why everyone believe here there's a firm culture. There's a firm culture. There's a law firm which they recruit one of the best students. Like the way we do, we take all the best. So we'll take you, we'll give you the chance, we'll work with you, we'll do a performance appraisal. If you don't perform, we'll tell you the truth. Because not all, as Senior Chugura said, not all lawyers they are meant to be in a law firm. Some others lawyers they are meant to be in-house lawyer. And you may find someone is very good performing well while he's in-house. But to being a lawyer who is working with a law firm, you need to have an extra talent, not only performing legal research, but also to bring clients. As Chungura said, and bringing clients does not mean that you are, like into a water, like you are connecting. No. Also, your brain. can make clients come to you because of either your specialization or because of the good work which you do. So that would be my issue.
Thank you. So performance appraisals, and you have to perform well to be able to get to a certain level. That's the message I hear. Mama, just a minute maybe of your observation on what Hamza was just speaking about in terms of unfair distribution and cries from these young lawyers that